Hi guys, in this video we're going to smash through law enforcement and punishment in the Anglo-Saxon, Norman and later medieval era from the crime and punishment topic in your exams. Let's jump in. We'll begin today's video with the Anglo-Saxons, looking at the structure of Anglo-Saxon society, the most common types of crime, how the law was enforced, and the main types of punishment. The key themes of this will be the tithings and the hue and cry, the use of deterrence and retribution in punishment, capital and corporal punishment, and the use of wergild. After this, we'll explore Norman and later medieval England and the crimes, law enforcement and punishment in this era. The key themes we'll explore in this era are the changing definitions of crime, especially after the Norman conquest, including the forest laws of William the Conqueror. We will also explore the expanding role of the king and local government in enforcing law and punishment, including the use of parish constables. And finally, we'll take a look at the end of the wergild. Let's jump in. There was a clear order of power in Anglo-Saxon society, with the king holding the most power in the country. Below the king were the nobles, who were wealthy landowners who advised the king and enforced the law. They also gave orders to the knights, who fought for the king during times of war. The vast majority of people in England were peasants. Peasants mostly lived in villages, and their work revolved around agriculture. Most of them were farmers. Christianity was the main religion in England at this time, and there was strict attendance of the church, enforced by the authorities. Anglo-Saxon crimes can be split into the three types of crime: crimes against the person, crimes against property, and crimes against authority. The most common crimes against the person in Anglo-Saxon times were murder, assault, and public disorder. One of the most common types of crime against property was poaching. This was considered a social crime, which means although it was outlawed, most people viewed it as morally acceptable and justified. This was because most poachers were just peasants who were trying to feed their family. Other types of crime against property include arson, petty theft, and ploughing land you don't legally own. The most common types of crime against authority were treason and betraying your lord. If you were a peasant, you had a local lord who you worked for. Now, as there was no police force at this time, enforcing the law was the collective responsibility of the local community. One way in which law enforcement was organised was the use of tithings. Tithings were groups of 10 male villages. If one of the 10 villages committed a crime, the other 9 were responsible for bringing him to court and charging him. From the age of 12, you joined a tithing in Anglo-Saxon England. The other main way the law was enforced was the use of hue and cry. This was a method of raising alarm in a local village when a crime had been committed. Either the victim of the crime or a witness to the crime would shout loudly. All villagers must stop what they're doing, even if they're working, and chase the criminal. If you refused to join a hue and cry, you would face a fine. There were two main types of trial in Anglo-Saxon England. Firstly, trial by local jury, and secondly, trial by ordeal. In a trial by local jury, it was the men in the local village where the crime was committed that would decide the outcome of the trial. This was because these men often had the most knowledge about the crime, because they knew both the accuser and the accused. This meant that reputation of people and character judgments were very influential in determining the outcome for the criminal. If a local jury could not come to a decision, a trial by ordeal was used. These trials were known as Judicium Dei, or God's judgment. If you faced a trial by ordeal, you had to fast for 3 days before the trial and listen to Mass. You did not want to have a trial by ordeal if you were a criminal in Anglo-Saxon England. They were very painful and traumatic. There are several types of trials by ordeal. One would be trial by hot water or hot iron. If you were given a hot water trial, you had to put your hand in a pot of boiling water and pull out an object. If you were given a hot iron trial, you had to hold a very hot iron weight. If the wounds you received from doing this healed within 3 days, you were deemed as having God on your side, and therefore being innocent. The next type of trial by ordeal is trial by cold water. You were tied up and dropped into water, and if you sank, you were innocent. But also if you sank, you drowned. So really there was no winning in this scenario. And sometimes you had trial by blessed bread. You would be given bread to eat, and if you choked on the bread, you were deemed guilty. If you did not choke, you were deemed innocent. Anglo-Saxon authorities had the aim of deterrence and retribution when handing out punishments. They wanted to deter criminals from committing crimes and take revenge on those who did. The most severe form of punishment was capital punishment. This was the death sentence. Typically, you were killed by hanging. You may be punished in this way if you commit treason or murder. However, only the most barbaric or the most dangerous murderers would face hanging. Most murderers just paid a fine known as a wergild. Corporal punishments were punishments that involved physical pain. For example, mutilation. This was used typically on repeat offenders of petty theft. There were also punishments designed to humiliate the criminal. Most typically, they used the pillory and stocks. The pillory was a wooden frame with holes for your head and your hands, and stocks were the same thing but for your feet. You would be put in the pillory or the stocks in a public place so your local villagers can see you and maybe even throw stones or rotten vegetables at you for the crime you committed. Wergild and botgild were fines paid by criminals for committing violent acts. Wergild was for crimes that led to the death of the victim, and botgild for crimes that led to physical harm to the victim. Originally, these fines were paid to the victim. However, eventually the king took all payments from these fines. Wergilds brought an end to the use of blood feuds. Blood feuds were when the victim's family and the criminal's family would inflict harm on one another. This led to retaliation from generation to generation. Blood feuds could go on for decades. The king was responsible for setting the price of the fine. The amount you had to pay depended on the status of the victim. If you killed a prince, you had to pay a fine of 1,500 shillings. But if you only killed a peasant, you only had to pay 40 shillings. The Anglo-Saxon period came to an end when William, Duke of Normandy, or William the Conqueror, won the Battle of Hastings in 1066. This led to a change in the definitions of crimes, as new laws were introduced to protect William's authority. The forest laws restricted the rights of peasants to hunt, gather wood, or graze animals. William reserved vast amounts of land for royal hunting only. Some of the offences under the forest laws included poaching royal game and cutting down trees. There were severe punishments for those who broke these laws. If you were caught hunting deer, you had your first 2 fingers cut off to prevent you from using a bow and arrow ever again. These laws were hugely unpopular with peasants who relied on hunting and poaching to feed their families. The forest laws just protected the rights of wealthy landowners and disregarded the vast majority of people in England, the peasants. The forest laws were viewed as a social crime. It was not often reported by peasants. Another change in Norman England was the use of murdrum. The Normans were under threat by the Anglo-Saxons in England, as the Anglo-Saxons disliked the Normans for invading their country. If a Norman was killed and the murderer was not captured, the entire region was responsible for paying the fine. Now let's look at the main changes and continuities from the Anglo-Saxons to the Normans. The collective responsibility of the local community to enforce the law continued through the use of tithings, the hue and cry, and trial by ordeal. However, there were some major changes too. Later medieval kings increased their role and responsibility in law enforcement and punishment as time went on. William's concerns over a potential rebellion by Anglo-Saxons led to more harsh attitudes towards law enforcement and punishment. William believed that committing a crime was an act against the king's peace, which was the king's duty to maintain law and order in England. There were many new ideas and changes in Norman England. Let's look at some of these now. Firstly, the sheriff and posse. Each region had a local sheriff who would organise a group of men called a posse to catch criminals on the run. A major change in the court system in England was the introduction of manor courts in Norman England. These dealt with minor crimes like petty theft and debt, often committed by peasants. We also saw in Norman England the introduction of a new trial by ordeal, trial by combat. This was when the accused and the accuser would fight until the death, or until one of them could no longer fight. If you could no longer fight, you were executed. Another crucial change in the court system in England was the introduction of church courts. These courts dealt specifically with crimes committed by churchmen. These were more lenient courts with no capital punishment, so you could not be sentenced to death. The use of royal courts began in 1163 under Henry II for the most serious crimes like murder and treason. The king appointed courtiers to determine the outcome of the trials. Coroners were employed from 1194 under Richard I. Coroners would investigate unnatural or suspicious deaths. They were also appointed by the king. Another major change in law enforcement was the introduction of justices of the peace from 1195 under Richard I. At the beginning, it was mostly knights who were justices of the peace. They would help to maintain local law and order, and they met 4 times a year to take part in the manor courts. They were also appointed by the king. So you can see this growing pattern of the king increasing his authority and control over law enforcement and punishment by deciding who gets employed in which positions and who's in charge of the courts. Parish constables were also used from 1285 under Edward I. These constables would maintain law and order in their local parish by arresting and punishing criminals. This was a part-time role with no weapons and no uniforms. The aim of punishment in Norman England was still deterrence and retribution. William I's attitudes towards criminals due to his fears of Anglo-Saxon rebellion led to increased use of capital punishment, corporal punishments and fines. However, the use of were-guild was brought to an end, as fines were now paid to the king and not the victims themselves. The idea of a prison system was first introduced in England under Henry II in 1166, under the Constitutions of Clarendon. This constitution was designed to increase royal power in England and remove power from the church, by introducing new courts called assize courts, and also introducing prisons to hold criminals while they awaited trial. However, the idea of prison as a sentence or punishment was not common at this time. Many criminals were pardoned by the king, in particular during wartime when soldiers were needed. Criminals would be given the choice to either face their punishment or join the war. This was used a lot between 1095 and 1291, the years of the Crusades. In later medieval England, high treason became a crime. This was plotting to assassinate the king. The punishment for this was being hanged, drawn and quartered. I won't go into the details of what being hanged, drawn and quartered involved because I may put you off your dinner, but you can give that a Google if you're interested. Now let's bring this all together into some key phrases to use in your exams when discussing this topic. There was a continuity in the aims of punishment during the medieval era, as ideas of retribution and deterrence remained prominent throughout the Anglo-Saxon era, Norman era, and later medieval England. The Normans coming to power in 1066 was a significant turning point, as it led to dramatic changes in attitudes towards crimes, law enforcement, and punishment. The Normans aimed to assert their authority and reduce the risk of rebellion by increasing the use of capital and corporal punishment. They also ended the Saxon War Guild and ordered that fines were paid to the king. Later medieval reforms led to significant changes, as the prison system for those awaiting trial was introduced, while fines became more common. High treason was also made punishable by death. Despite this, capital punishment gradually decreased in usage. This was partly due to the king's ability to serve pardons. The severity of punishments in medieval England were often determined by the social status of the accused. People who belonged to the lower classes of the feudal system faced more severe punishments. Women also typically faced harsher punishments, while the establishment of church courts under the Normans led to the clergy receiving more lenient punishments than the rest of society. Now let's go through some of the most common questions you get in exams on law enforcement and punishment in medieval England. Explain one way in which attitudes towards the crime of poaching during the medieval period were similar to attitudes towards the crime of poaching in the years 1700 to 1900. The main similarity is that authorities in both eras viewed poaching as a serious crime. Poaching had severe punishments in both eras. This was because authorities in both eras viewed poaching as an undermining of property rights and a threat to the resources of the wealthy landowners. It was also viewed as a challenge to authority, and they installed severe punishments to maintain the social order and hierarchy of the country. A 12 marker might be: explain how the justice system changed following the Norman conquest of 1066. Firstly, you can talk about how the justice system favoured Normans over Anglo-Saxons by talking about the use of murderums. Then you can talk about how the law was changed to be more severe towards peasants and protects the interests of the authorities, shown by William the Conqueror's forest laws and the effects of this. You could also talk about the changes in trials by ordeal, for example the use of trial by combat, and the other ideas we went through earlier in today's presentation. And finally, a long question might be: the idea of retribution was the main factor affecting methods of punishment during the medieval period. How far do you agree? The main themes to support the argument of the idea of retribution being the main factor affecting punishment would be the ideas of the death penalty, humiliation tactics like the pillory and the stocks, and of course fines and war guild. And then you can counter this by talking about deterrence. You can use the same examples of punishments that you just gave, but think about how they deter criminals. For example, the public punishments, like the death penalty, and the minor punishments that were still public, like the pillory and the stocks, but public so people could see, and they would be deterred to do the same crime themselves. And then you can conclude by saying that retribution and deterrence both existed at the same time in medieval England. They were both crucial aims of punishment during this time to maintain law and order. And that brings us to the end of law enforcement and punishment in medieval England. Have a go at those exam questions and revise your content from today, and I will see you all in the next video.